Court Law number 1 candidates for that particular position. So, gentlemen, if you'll please come forward. Prior to the meeting today, we went ahead and got our order in place in terms of who gets to introduce themselves with an opening statement first. Each one will have 2 minutes to give an opening statement. Then we'll go into a series of 6 questions. The first 3, which will be 2 minutes to respond. The second 3, if we can go that long, time depending. Lawyers tend to talk a long time, and all 4 of us are lawyers, so they know that when Kelly puts up the red card, that means they're supposed to be quiet and move on. And judges often tell us to do just that. A little bit of background about the actual position. I mean, we all know about judges a little bit, but don't necessarily know what the court does. And since the first 3 questions really are court related and talking about how that court functions, I thought it would be helpful for everybody to understand that the County Court at Law number 1 is a statutorily created court. It has jurisdiction over civil matters, criminal matters, that includes family law. They are also a probate court. However, because of the fact that all of the judges have gotten together and to try to maintain some good flow of cases through the court systems and allocation of caseload, the County Court at Law number 1 is currently a criminal court, meaning it handles criminal cases. They are misdemeanor cases. They are important, but the maximum punishment in a misdemeanor is $4,000 fine and or imprisonment in the jail of up to 1 year. They also, at this point, are allocated to take on 3% of the family law case filings, and those family law cases would be, typically divorces, custody cases, and that kind of thing. Probate appeals and those matters are handled by County Court at Law number 3 at this time under the current allocation.
Good afternoon. My name is Mark Hocker, and I am the currently appointed and sitting judge in County Court at Law number 1. I'm 43 years of age. I've been married for 15 years to the love of my life, Heather Hocker, who is a member of this organization and who I'm sure most of you know. She's better known around town than I am, and I'm proud of that because she does good work in this community. We are very actively involved in the Lubbock community. My most important membership is at First United Methodist Church, where I serve on a number of committees and participate in the worship service and in the Sunday school. And if you've ever seen me on TV reading the scripture and I messed up, I'm sorry. I think I'm the only person that ever did that, but I one time read the wrong scripture. And it was one of those deals where it was almost identical to what I was supposed to be reading. Instead of starting at verse 1, I started at verse 10. Because I get nervous when I read in church. I don't know why. I speak in public all the time, but that makes me nervous. And halfway through, I realized I'm not reading the right thing. And somebody out there's got their Bible open and they know it. And so I just stopped and admitted it, and then I read the right scripture, and the preacher said that was okay. But I'm 43 years old. I have a 5-year-old daughter who is just the apple of my eye. I have worked with both of these gentlemen for Judge Souter, the District Attorney Souter, and that was my privilege and honor. I was a criminal defense lawyer for almost 2 years here in Lubbock County, Texas, and I also, like Mr. Morris, worked up in the 242nd and 64th District Courts of Plainview. For the last 4 years before I was appointed, I worked as a civil litigator here in Lubbock for Alan Atkins' office. I've been to courthouses all over this state. I've seen how judges treat people, well and otherwise. I've spent a lot of time in misdemeanor courts, and I agree with Mr. Morris when he says that these misdemeanor crimes are gateway crimes. If you are ever involved in the criminal justice system as an accused person, it is most likely to occur in the misdemeanor courts. By the time you get to the felony level, you've probably already been through the misdemeanor court system. So what we do in those courts is really important. And I want you to know that I'm working hard, I'm innovating in that court, and it would be my pleasure to continue to represent Lubbock County in that court.
Okay, answer order here will be Mark, Scott, and Doug. By statute, criminal law cases take priority, but divorce and custody cases also need to be handled. Currently, there are approximately 2,000 cases, criminal cases pending in the court, and approximately 50 family law cases. How do you propose to ensure the timely disposition of the family law cases in the court's docket?
Thank you, Ms. Rosas. Right after I was appointed, I was contacted by the other judges to discuss the reallocation of family law cases. That's something that Judge Ladd had showed an interest in prior to his untimely death, and he and I had even discussed that at one point in time. So I knew that that was a possibility. I am welcoming the family law cases coming back to my court. I'm getting about 3% of all the filings. They tell me it'll be about 45, 46 cases a year, maybe as many as 50. Most of those cases work themselves out. It'll probably take about 5 or 6 hearings a year is what I'm advised of by David Slayton, the Director of Court Administration, who has looked into this and knows about it. Originally, it was proposed, well, you need to set one Friday a month to handle these family law cases. And I said, if we're only going to have 5 or 6 hearings a year, there's no reason to set aside all that time, because we're going to be having nothing a lot of that time when we could be doing something else. So it is my plan in this court to work those cases in with our other settings. We may not want to set them at the same time as our criminal cases, but one of the things that we're doing in my court is I'm right now drafting, and I've already circulated it to some other judges, a scheduling order to help better move our criminal cases along, and that's going to free up some time in our court, and we're going to be able to accommodate the family law cases whenever they need a hearing for as long as they need them. It's going to be easy to fit them in.
Plea bargaining is a necessary evil, if you will, to keep cases moving through the court system. Currently, the county courts at law are moving or disposing of as many cases are coming in. So, kudos to them for being able to keep things moving. There is, in the process of the current court system, a thing called plea negotiation conference. It's a setting where both the lawyer and the client have to be present, as well as the prosecution. Some would argue that the plea negotiation conference system isn't working. Do you believe that the current system is working? Explain why or why not, and if not, what you would do to fix it.
I was on the committee. I was the district attorney's representative for the committee that went to Harris County and Montgomery County when we looked at doing this plea negotiation system 10 years ago. And they were doing it down there, and it was working rather effectively for them down there. But they had some real strict enforcements, and I didn't think it was going to work here because I didn't think we were going to be strict enough with it. And I think that's proven itself out. I think all three of us are agreeing that the system is not working. Is it completely broken? No, but it's like that old clunker car that you don't know if it's going to start every day, and you don't know if you're always going to get to your destination, so you carry an extra gas can and some jumper cables, and you try to hope you get there. We need a much better system. I disagree with the idea that we need to have that defendant come to the courthouse so often that it becomes inconvenient, and that becomes his motivation for taking a plea, because he just doesn't want to be inconvenienced anymore. I don't have a problem with him being inconvenienced sitting in jail as punishment for a crime he committed, or serving on probation or anything else. But in the process, while the presumption of innocence remains, we should not simply create a system that is so difficult for a person that they'll just plead to get out of the system. That is not right. But we do need to have a more efficient system. What I have instituted, or am going to institute, we're in the process of doing right now, is a scheduling order system, where we're going to bring the defendant in for announcement. And the Supreme Court and our Lubbock County rules require that we resolve a misdemeanor case within 180 days. Currently, about 60% of them are getting there. You'll never have 100% because of fugitives, because of felonies pending, and other things. But we've got to do better than that. Court 2 is doing 75% within 180 days, and we're only doing 60 in Court 1 historically, so we've got to improve this. We're going to bring them in for arraignment. We're going to give them 2 weeks to go hire an attorney. If they don't qualify for an appointed one up front, we're going to give them one more set of 2 weeks to go hire an attorney. Then we're going to have a discovery deadline where the discovery is supposed to be exchanged, and the DA has an open file policy, so that's going to work really well. That's going to make the defense attorney go and get that discovery. Then we're going to have status conferences. We're going to have a pretrial filing motion, a deadline to file the motions. We're going to have the hearing. We're going to set them on a jury trial docket.
For those of you who are not in the court system, you're probably bored to death. Order on this one, Doug, Mark, Scott. There is a discrepancy in the number of cases that are pending in the 2 different courts, which has just been brought out. There is a procedure called administrative closure, which is a way to clear the docket without actually dismissing a case. Typically what happens in most jurisdictions is that if you've got a felony pending, and you also have a misdemeanor pending, then you let the misdemeanor kind of hang around for a while till they decide what's going to happen on the felony. So it's a procedure that can be used if the court chooses to clear their docket, or sort of clear their docket, because the case is still pending. So, gentlemen, what is your position on using the administrative closure procedure and why?
Kelly, you're not going to need your stopwatch. I don't need a minute and a half to answer this question. We're not doing administrative closures in my court. As our former governor and president used to say, I think that's fuzzy math. It's just a way of playing with the numbers to try to make your stats look better. It has nothing to do with resolving or moving a case at all. We've got to keep those cases on the docket. We've got to keep track of them. They may be set aside for one reason or another. Felonies do take precedence over misdemeanors most of the time, but we're not just going to close those cases out in my court and pretend like they don't exist.
Mark, Scott, Doug. In your responses today, you've all, and let me back up, we're all prosecutors at heart, all four of us. Because we've all been there and served our time, and some of us continue to be in that area. But you've all seemed to lay total blame on the defense attorney in terms of not moving cases. Do you believe that the prosecutors have anything to do with the failure of the PNC system? And if so, what would you do to fix it?
Wow, it's not good to get put on the side and say, hey, would you criticize the DA? I like that pal. I like the prosecutors that are in my office. I like the gentlemen up here that I have served with, and I've done their job and I know what they have to do. Under the PNC system as it's supposed to be designed, an offer is supposed to be communicated to the defense attorney 10 days before the hearing, and that offer is supposed to be a serious offer, which means they've sat down, they've looked through the case, they've really analyzed it, maybe even talked to the victim. The reality is that's impossible when you're filing 2,000 cases a year in one court for just 2 or 3 lawyers in that court to go through and talk to all those victims and review every videotape and do everything they can. I mean, these guys are up there and they're working hard, but that's unrealistic to think that they'll do that. 10 days before the PNC, the offer goes out, then the defense attorney has time to get it and go over it with his client. Well, those clients don't always return calls, and they don't always get back to you either. And so what ends up happening, here's the way the PNCs work today. The district attorney goes up there, well, he used to go up there with a bucket of files, now they may go up there with their computer, because everything's electronic. And the defense attorneys get in line. And by the way, they're billing the county for all those hours they stand in line. The other day I had 3 prosecutors in my court working as fast as they could. There were 3 lawyers talking to all of them, and there were 9 more standing in line. And when I get those requests to pay counsel, when they're appointed and they're billing an hour for every PNC, and when it's taken 3.67 PNCs to get a case resolved before it goes to a jury trial, that's a huge waste of our county's resources. It's a huge waste of the lawyer's time. It's not fair to the DAs. It's not fair to the defense attorneys. The only way plea negotiations are going to work is if we get both sides working together. And they've got to communicate. And I think this idea that, well, we'll bring them all to the courtroom and we'll make them communicate has not worked. Because, as somebody else said, there hasn't been any consequences when the defendant doesn't show up or when nothing happens. So we're going to go to a scheduling order. There's going to be set deadlines to have things done. And then we're going to hold them accountable by pushing to trial, if nothing else. Trial's the only thing a judge can do to hold the lawyer's feet to the fire. But we're going to do that.
1 minute on this one. So, as you go through the campaign, of course, we get to hear all the political rhetoric, and one of the questions I always like to ask has to do with getting to know or know some little tidbit about you as a candidate or as a person from your childhood. It doesn't matter what it is, but it's something that we can take back with us and go, oh yeah, I remember Doug telling me about X. So, gentlemen, would you please share a short, very short, because you only got a minute, story, whether it's funny or just something you want us to know about you as we get ready to go to the polls.
This may not be as young as Scott or Doug's story, but it seems like I was a kid back then. But in 1990, the Army sent me to Honduras for a month. And I was a reservist. I served 7 years in the United States Army Reserve. And I was a helicopter crew chief, which meant I fixed the helicopters and worked on them. And occasionally I got to fly up front with the pilots. And we flew on an Air Force plane down there, and it was a very uncomfortable flight. We were packed in like cattle going from San Antonio to Honduras. And we landed in Tegucigalpa, Honduras, at an Air Force base there, and they dropped the bag at the ramp. And we came walking off, and we thought, now this was during the Contras and the Sandinistas were fighting. If you remember the Iran-Contra deal, and they funded the Contras, and we were building roads, so we were not technically supporting the war, and I won't say anything more about that. But this Chinook helicopter backed into a telephone pole on the edge of the base. And the back rotors, those things have twin rotors, and the back rotors hit that pole, they started colliding with the front rotors, stuff started going everywhere, and we just all hit the ground as these rotor blades and helicopter parts flew over our head. And I remember thinking, God, it's humid here, it's just like Houston.
So we can try to get out of here pretty close to 1. We'll have a 1 minute wrapped up from each of the candidates, and do you all remember? Scott, Doug, Mark.
I want to thank you for taking the time to listen to us here today. On all of your tables is a card that has some information about me. Please take those with you. We didn't print them up for ourselves, so I hope you'll enjoy them. On that card is a pledge, and you'll see that I've signed it, and I wanted to say that in front of you here today. As your judge in County Court at Law Number 1, I will respect the Constitution and the law as written. I do not participate in judicial activism. I believe in restraint. I will administer fair and impartial justice. I will treat others with the respect and the dignity that every human life deserves. And I will work hard for the citizens of Lubbock County. If you'll consider giving me your support, I have some campaign yard signs by the front door. Please take one and put it in your yard and tell your neighbors your decision. Thank you.
Thank you all for your responses. I know that Judge Hocker will have to leave fairly quickly because of jury trial, and he doesn't want to keep the citizens waiting. But as soon as we're adjourned, I'm sure that they'll stay around as long as they can and try to take questions individually. Thank you.
Just want to thank all of you again. That was a great, informative session. We really appreciate you coming to participate and wish you well. Also appreciate Marta, our resident moderator, so I think she did a great job. Just invite you to visit with each of the candidates after the meeting if you have time.